And now I will turn it over to Andrew and Sharon.
Hello, this is Sharon Dietrich speaking. Welcome to the webinar. I just saw a chat saying that the person could not hear anything. Please remember that you need, well, I guess that's not going to really be responded to on the phone, is it? Kelly, could you respond to that? All right, thanks. Okay, so I am the head of the employment unit at Community Legal Services, and we started working on the issue of court debt back in the year 2011. That was the point at which the First Judicial District of Pennsylvania, the Philadelphia courts, announced that they were going to start trying to collect court debt that went back as far as the 1970s. And our clients started to get notices in the mail telling them that they owed very substantial amounts of debt, sometimes in the tens of thousands, sometimes occasionally even in the six figures for bail judgments and other types of things that we'll be talking about today. CLS and the employment unit got involved not only because these debts were standing in the way of getting cases expunged and sealed at some points, but also because we had as much experience as anyone in our program with the criminal justice system and with the Criminal Justice Center. And our clients were quite frankly terrified by the thought that this debt that they owed and were being asked to pay might send them to jail or send them back to jail. So we have been very active on this issue since then in our case handling and otherwise. We got the courts in Philadelphia to write off $1 billion of old bail forfeitures. But there's still, unfortunately, about another $1.5 billion that are still on the books for the population of Pennsylvania, or Philadelphia, rather. So that's me and CLS's interest in this issue, and I'm glad to introduce you to Andrew Christie, who I think probably most of you do not know. Andrew is a terrific resource on this issue for the entire state. So Andrew, if you'd say hello and explain to people what it is you do and how you can help.
Thank you, Sharon. So for the past 2 years, I've been a lawyer here at the ACLU in our Philadelphia office, primarily focusing on court fines, costs, and restitution, both the imposition and then the downstream consequences. My work initially was focused on trying to keep people out of jail who were too poor to pay their fines and costs. And unfortunately, some judges in some parts of the state will not hesitate to throw people in jail if they haven't been making their payments. And so a lot of my initial focus was on making, trying to limit the frequency with which that happens. And pretty quickly, I started broadening my approach into related issues, such as getting rid of the court debt so that you don't have to, so that you don't owe it in the first place and don't risk any of those collateral consequences. And that leads naturally into the sealing and clean slate and the great work that Sharon and her colleagues at CLS have done to make this a reality. I am, in a way, I think of sort of the way that I can support you legal aid folks is through essentially technical assistance. I've drafted a number of template motions, some of which we'll talk about here, and we have more resources on our website, some legal guides, and to the extent that there are issues that you're dealing with that you don't think are fair for your clients based on their poverty, I might potentially be interested in working with you on some litigation. And so, I just want to be here to support you since you all are doing the front lines work.
Thank you, Andrew. All right, next slide, please.
There we go.
Thank you. So these are the topics as promised in the invite to this webinar that we will be covering today. In particular, I want to say that we initially focused this webinar on eliminating court debt in order to facilitate clearing of criminal records by sealing and expungement. I realize that a healthy minority of people on the call or on the webinar today are actually not employment lawyers doing those things. So we'll do our best to be a little bit broader as we talk about these issues that do, in fact, have implications for certainly consumer law and other types of practice as well. So primarily, we'll talk about how to find out whether your court owes, or whether your client owes court debt, how to get it paid, how to make arrangements to pay it. Very importantly, how to cut down on court debt or eliminate it entirely. And then the role of collection agencies, which unfortunately can be quite onerous, and other possible risks of not dealing with debt. Andrew?
Nothing to add.
Okay, thank you. Just to get this out of the way right away, since I know most of the folks on the call are in LSC-funded programs, NLADA did us the honor and the helpful act of writing an extensive memo explaining why work in this area generally is not restricted. And that's one of the materials that you will find available to you through the website at the end of this program. NLADA talks about how these types of representations of clients are not, quote unquote, criminal proceedings that are prohibited because they do not involve guilt or innocence or even sentencing. They involve post-sentence activity like expungement that NLADA and LSC have recognized are not covered by that restriction, nor is working on court debt, even to reduce the amount, considered a collateral attack on criminal convictions. And typically our programs are not representing prisoners in these types of cases, so that's not an issue as well. So consult the extensive and exhaustive general counsel guidance from NLADA if you need to know more about this, but in general, do not fear. We are in good shape in terms of being able to help clients in these cases.
And I think that Kelly has also shared that memo along with a couple of other documents in the chat box as well, for those of you who know how to access that, and otherwise it'll be available at the end of the presentation if you don't know, so it's all good. So we want to make sure that we're all on the same page in terms of the types of court debt that we're talking about here. Every person who is convicted of any criminal offense, and by that I mean a misdemeanor or felony, as well as people convicted of summary offenses, including traffic offenses, comes away with some combination of fines, costs, and restitution, except in a small number of cases where defense lawyers get those financial obligations waived at sentencing. But in general, there are lots of people who owe money every year through these cases. The first time, and usually we talk about fines and costs interchangeably, but there are distinctions, some of which are going to matter in terms of what your options are for your clients. So fines are punishment. They're sort of like they're part of the sentence, just like a jail sentence. And in general, they can't be modified more than 30 days after sentencing. So if your client has a lot of fines, they're probably stuck with them. Now, the good news is fines are not assessed in every case and tend not to be the largest source of court debt. The largest source of court debt instead usually is in the costs category. Costs are, through some arcane aspects of Pennsylvania jurisprudence, not technically part of the sentence. They are, quote unquote, incident to judgment, and they're not considered a punishment. The costs are automatically imposed but by virtue of having been convicted, even if a judge does not issue a specific order imposing them. Like I said, they tend to be the largest chunk of money. An average public defender client comes out owing about $1,600 in court costs alone. And within this cost category, it also includes something called supervision fees, which is a monthly fee that the defendant has the privilege of paying for the benefit of being on probation or parole, which can add up to be quite a bit. And the supervision fees are a minimum of $25. They're $25 per month in Philadelphia. In a number of counties, they've been increased to like $40 or $50 a month. And in a few minutes, we'll show you an example of a docket sheet so that you can see what all these different types of financial assessments look like. And we'll talk about how to interpret that when you're taking a look at that. And the last category of restitution, this is the compensation to the victim. And this is usually courts are focused most on collecting this money and also making sure that the victim, at sentencing, making sure that the victim has as much compensation as possible. So a lot of what we're going to be talking about later in this presentation about potentially waiving or reducing the amount of money that's owed is primarily focused on that middle category of court costs.
Let's add on the restitution piece that a common thing that legal aid lawyers see for restitution obligations are institutional restitution orders. So in particular, in welfare fraud cases, it may be that the client has been told to pay back thousands of dollars to the welfare department. Or if the case was about theft of utility services, the restitution might be to the utility. So we often think about restitution as, somebody got into a fight and the victim had injuries and medical costs, but in fact, it can be these institutional costs as well. And they often are quite heavy and quite frankly, difficult to get the client out from under.
Yeah, that's a very good point. And when you have large amounts of money, whether it's fines, costs, or restitution, you include to DHS, it can follow defendants for years or quite literally decades. There is no statute of limitations on collecting this court debt. It hangs out there until it's collected, or until the person dies. I mean, some people are literally going to be paying this money off for the rest of their lives, and the people who indigent defendants and people who are seeking legal aid services, I'm sure I'm preaching to the choir, often aren't in a capacity to really pay that money off, which is why some of the stats that I've gotten from the state court system taking a look at this show that people represented by the public defender tend to still owe a big chunk of that money, particularly compared to people who are represented by private counsel. And state courts, individual courts, spend a lot of time and effort trying to collect this money, some of them aggressively, and there's not necessarily a lot to show from it, because the collections tend to really top off after about 4 to 5 years and pretty much flatline at that point.
Andrew's point on there being no statute of limitations reminds me of another important point to make, which is that many consumer remedies that protect people from ordinary debt do not necessarily apply in this context. In fact, if you look at those remedies, you'll see that there are often explicit exclusions for government debt or court debt or criminal debt, however it may be written in a particular statute. So if you come up with the bright idea of using one of those statutes, just be sure to take a look at coverage to make sure it applies to this kind of debt. Okay, downstream consequences. Court debt's got collateral consequences of its own besides just owing the debt, similar to how criminal convictions themselves have collateral consequences. One of the main reasons that we decided to hold the webinar at this time is that we're about to be in a position here in Pennsylvania to automatically seal a huge amount of criminal convictions, except for the fact that folks will not be eligible unless their fines and costs are zeroed out. So an early look at the data of cases that can be sealed in Pennsylvania by this automated system, which is going to be the first in the country, and we're very proud of it, is that currently, of cases in the common pleas and municipal court in Philadelphia system that we've looked at, 17% are eligible for automated sealing, which is enormous and makes us extremely happy about what we think we've accomplished in getting that law passed. However, if the fines and costs for that are making some people ineligible were eliminated, that number would rise from 17% to 31%. In other words, it would almost double. So clearly, for our clients to benefit from the new, really robust law that's going to seal many convictions, also non-convictions, but they ordinarily do not have fines and costs attached. For us as a legal aid community to make that happen as robustly as possible, we try to eliminate people's fines and costs if they're going to be eligible for sealing a 10-year-old misdemeanor or a 5-year-old summary offense. Community Legal Services has taken a very aggressive approach to that. We have made a request to the City of Philadelphia about potentially waiving court debt that is more than 10 years old. So we'll see whether we're able to do something in a mass way like that to enable more of our clients to benefit from Clean Slate. All right, but in addition to Clean Slate, if you have court debt and you are not on a payment plan, you will have problems obtaining certain public benefits, notably TANF and general assistance. If you have a driver's license, it may be suspended if you owe these court debts. And there's also ever present the lurking fear, especially in certain places, not so much here in Philadelphia, but in other places certainly, that if you owe debt, you may face incarceration.
And on that point, I see that there's a question about how much money the courts spend trying to collect this. And I think the truth is that no one really knows. There's not any research on. Well, some courts take the position, like the Philadelphia Court of Common Pleas, for example, takes the position that information about their financial information about their court collections practices is not a financial record that is subject to public disclosure. And there's not really any academic research in terms of if it is a more aggressive approach bringing in more money for the court, and that money gets split up depending on the offense to the municipality, to the county, and to the state. So the answer really is that no one knows how much courts are spending on it, and no one knows whether courts that are spending a lot of time and effort on it are actually seeing any dividends for their efforts. I also want to mention, with respect to driver's license suspensions, the driver's license suspensions are in traffic cases. If you're not making your payments, they can suspend your license. There was a bill passed this year that stops automatic driver's license suspensions as a result of being convicted in certain offenses, including drug crimes. And some of the press coverage said that Pennsylvania has stopped driver's license suspensions for all non-driving related offenses. But unfortunately, there's a little more nuance there. And so your clients still very much are at risk of having their driver's licenses suspended simply for falling behind on their payments in traffic cases.
Sharon and Andrew, if I could just interrupt here for a moment. I'm going to launch the first of the CLE polls for attorneys that would like to request the one substantive CLE credit for your participation in the webinar. Please respond to the poll now. You have 2 minutes to do so. And thank you. You can go back to your presentation.
Thank you, Kelly. So while you're putting in your poll information, let me just give you a little bit of background on practicing in this area if you are new to it, before we launch into the substantive rules. If you feel like you're seeing more discussion of court debt now than you did in the past, I think that's absolutely true. And in part, that is the case. It has been well documented. that court debt has kind of replaced tax increases as a way for states and in some places, localities, to raise income. So not only are enforcement efforts more robust than they may have been once upon a time, but also the types of different kinds of penalties and costs and fines and things of that nature that you'll see on people's dockets really are more numerous than they were in the past, because this is how money's been raised for all kinds of things that are not even necessarily related to a criminal case. I also wanted to mention that you will encounter some kind of attitude among court staff sometimes because of this. My experience here in Philadelphia is that court staff, and I'm not just talking about judges, but maybe to some extent judges as well, believe that court debt helps keep a roof over their heads and keeps a paycheck coming. The courts have been encouraged that this is a way, collecting court debt, to supplement their stagnant appropriations from the General Assembly. So unfortunately, sometimes these beliefs are not accurate, sometimes they are, but you may expect to find a certain amount of reluctance to listen to what you're presenting when you first undertake this kind of representation. Do not let that deter you, because clients' attitudes toward court debt, in my experience, are that they hate to have it on their records. They would love to be rid of it, but our low-income clients in particular usually do not have funds sitting around that they can see how they can take away from feeding their kids and keeping a roof over their heads to paying to the courts. And what I often find with my clients is that they have not been making payments, not because they don't want to, but because there are much more imminent problems that they need to devote their resources toward. In many cases, clients are absolutely terrified to owe this debt, because this is not like a normal creditor where, yes, they can take you to court and try to get a judgment against you. These are people that may have put them in jail in the past, or that they worry will put them in jail in the future. So this is a different kind of debt, and clients sometimes don't care too much about it and sometimes care a great deal, but in many cases, they're just not able to make payments. During the height of our work here in Philadelphia on fines and costs, we would go to payment plan conferences where people would be talking about their source of income being that they were picking up aluminum cans on the side of the road. And nevertheless, the court staff told them, well, it sounds to us like you could pay us $5 a month. So that's sort of the reality of what we're dealing with these cases here.
And I'll say that the law does not really back up with what the court staff were doing in that scenario. Essentially, if you can't meet, as we'll talk about later, if you can't meet your basic life needs, the court shouldn't be compelling you to make payments. And so, there's some wiggle room and wishy-washiness about that type of standard, but our appellate courts are reasonably helpful in showing that if all you're doing is collecting cans along the side of the road, the court debt should be the least of your problems, and the court shouldn't be harassing you about it. Sharon, there's a question about whether there's been any research connecting court debt and Philadelphia's status as one of the poorest large cities in America. I'm unaware of anything along those lines, but do you have any thoughts?
I don't know that I've seen court debt really considered as part of the analysis of why our residents are so poor, but surely the poverty that our residents have keep them from paying the debt, especially when it's in the many hundreds of dollars. We're not talking about an amount of money that even middle-class people would feel real comfortable writing checks for usually. So there's no question that our very low-income clients are not going to be able to pay it.
Yeah, we're often talking easily a couple of $1,000s, which is well outside of that ballpark.
All right. So as great as the Clean Slate law is in many respects, one thing that is not good about it is that the General Assembly specifically put in language that say that to be eligible for either automated sealing or sealing by petition in a case involving a misdemeanor conviction that you would want to seal by petition, you need to have completion of each court-ordered financial obligation of the sentence. The law was not that clear before the Clean Slate law was enacted. I will say that the court rules governing expungement petitions did require both the petitioner to talk about what fines and costs they owed and whether they were paid, and also for the judge to make a ruling. So while there was no explicit legal requirement that court fines and costs be satisfied to get your case sealed or expunged, certainly people encountered that. And in fact, in my experience, CPCMS, the court's computer system, cannot allow clerical staff to close up an expunged case if fines and costs are still owed. In fact, I've seen them not expunge a case where money is owed back to the individual, that a check needs to be sent out in cash before they will expunge a case because of how the computer system is set up. Now, this is not true for partial expungements where the case will continue but this is something that we've gone back and forth with the court staff in Philadelphia about quite a bit, and I'm imagining many of you have encountered this as well. ARD is also, it's not explicit about the dealing with court fines and costs. I think most judges would believe that you need fines and costs paid before they're going to seal or expunge an ARD. But I would remind you that Rule 316, if you look at the rules on ARD, does note that restitution is the only required type of court debt in an ARD case. Unfortunately, that is a rule that has been honored more in the breach than in the enforcement, and it would be nice to see ARD have a little less cost connected to it than we've seen recently. So maybe that's something that can be worked on in the future. Andrew, want to add anything on that?
Oh, you know that I do. Certainly our position at the ACLU is that specifically with respect to ARD, people who can't afford to pay their financial obligations that ordinarily go along with ARD should either have those obligations waived or still be permitted to successfully complete ARD and get an expungement, and then perhaps a civil judgment will still stand against them, but at least the case would go away. And I say this only by way of saying that if any of you are having issues in your county with ARD and your client's not getting the relief that they would be able to get if they could afford to pay for it, please feel free to reach out to me, and I'd love to chat with you about it and see what options there are. Okay. Checking into your client's financial status is actually fairly straightforward because we have a pretty decent state court website. I'm sure many of you have looked at criminal dockets before, but basically you can go on the AOPC's Unified Judicial System website and look up and type in your client's name and date of birth or whatever other information might help you narrow it down, and pull up their docket sheets and their criminal cases that will show you exactly how much money they owe in fines, costs, and restitution. And I've just included here for your convenience the link to the common pleas pages as well as the magisterial district courts. It could also be worth calling the clerk of courts or whatever it may be called in your locale, but whoever administratively handles all of the filings and paperwork on the criminal side to ask how much your client owes. Some courts, like in Philadelphia, there's a consolidated report of all of the money that a defendant owes across all of his or her criminal cases. So that might be something that your local court could generate for you as well, just to save you a little bit of trouble. And when we're talking about fines and costs, this is an example of what a docket sheet looks like. And I hope it's big enough for you, but I wanted to capture one that has a lot of costs and also two different categories. So the basic breakdown, as you can see at the top, it tells you the last time this person made a payment, how much was paid, defendant's name, and then it has the heading costs/fees. And here it lists the line items of all of the court costs that have been assessed against this individual defendant. And there are some of these have statutes backing them up, like the Crime Victims Compensation Act, Act 96 of 1984. So that's fairly straightforward. You could look and figure out what that is. Not all of them have those citations. I've actually, in my free time, gone through and identified pretty much all of them, and have up on our website a breakdown of the statutory authority for them in case you're ever curious. But this is what a docket sheet looks like. Then the next and then at the bottom you'll see there's a separate category for fines. And if this defendant also owed restitution, there would be another category for restitution as well. And that'll show you. That's just an easy way to look at and see how much they owe in each of these types of court debt. I want to note that this is actually a slightly bad pick in a way, and I apologize because this does not include any supervision fees on it. And if you look at a docket and look for a line item under the court costs that says OSP, as in Offender Supervision Program, there will be two line items of OSP, and that's because some of the supervision fees go to the state, and some of them go to the county court's probation office. And so what happens is if you owe $500 in supervision fees, it'll say OSP $250 to the state, and then OSP $250 to the county, and that's why it shows up twice on docket sheets when there are supervision fees. So ideally, courts would love to have defendants pay money, and many of your clients may be unable to pay, but some of them might be able to pay, and they just need a little bit of guidance on what they can do. Each court has a different system in place for doing the collections. The best place to start, if you don't know how it works in your county court of common pleas, is to get in touch with your local clerk of court's office and just ask who collects the fines, costs, and restitution, what their procedures are, who your client needs to talk to about getting on a payment plan if they can afford to pay. You can also make payments online. There's a ridiculous $2.75 transaction fee. So if you have someone who's on a $5 a month payment plan and they want to pay online, they're paying more in the transaction fee than, they're paying half in the transaction fee compared to their payments. It also, my experience, and I think this has been Sharon's as well, the defendant often doesn't have any choice as to where the money goes in terms of which case it goes to. So for example, if I have two cases and I want to pay off the newer case because that one might be eligible to be sealed under clean slate, if I make a $50 payment to the court decides where that money goes. It's often out of the hands of the defendant. Along the same lines, the court has a procedure to determine if you make a $50 payment, where does that money get split up? It doesn't all go to pay your fines or your restitution. Instead, it gets split up where some of it goes to restitution, and then some of it goes to the court costs in a prorated basis for those individual line items that we looked at in a previous slide. And fines are usually the last bit that are paid off. So it's unfortunate, but you don't have the ability to direct your payments to specific cases and specific line items most of the time. But it's worth checking with the clerk of courts to see what the options are, and perhaps that's something that you could get a court order from saying, all these payments need to go to this specific case because it's eligible for expungement or something like that.
Well, I want to add that one of the reasons for your client to pay online is that, in fact, you can direct payment toward a particular case. And just to make very clear what we're talking about here, let's say your client has scraped together $30 to make a payment, and there are 3 different criminal cases on that person's record that they owe court fines and costs in. If the client just shows up at the court and gives them $30, they're probably going to divide it between the 3 cases. And then they're going to further divide it between various court fines and costs. So let's say that one of those 3 cases can be expunged or sealed, and you want, your client's trying really hard to get the amount of money together that he or she can get to get that case sealed. You want to focus it at the case that is going to be expunged, because otherwise people have got to scrape up hundreds of dollars to pay all these cases to make it all go away. And by the way, you don't need to completely zero out your fines and costs on all cases in order to get it expunged or sealed, just the one you want expunged or sealed. So one way you can do that is to pay online at that link, but beware that it's a really wonky website. For one thing, you need to know like a docket number that you want to pay on. So clients need a little bit of help to get started by paying there online, and they also need a credit card to do it. So that's not going to be something available to all clients, but for many it will be. I've also had some success walking into the Criminal Justice Center here in Philadelphia and saying, this check is for this case, and they've taken it and applied it for that case. So potentially, if a client is armed with the information that they want to go in and not just hand over the check, but be specific what case they're paying for, or let's say if you send it in the mail for them, there may be ways to direct it to the specific case. Also, another implication here, since the debt is being spread, or the payment is being spread among the different debts, let's say you're going to work on getting someone's supervision fees waived, which we'll talk about in a minute. Do that before they start paying, because otherwise some of it is going to go into the supervision fee that you've gotten waived. And again, if your clients are like mine and trying to scrape the money together, that's money that they could have used to really bring things down to zero.
So if you have a client who can afford to pay, courts will afford to pay something, and again, that could be $5 a month, and that may or may not be good for a client who's trying to pay down a large amount of debt. The waiver that we're going to talk about in a minute could be a better option for them. But let's just assume that you have a client who has some ability to pay and wants to pay it down. Courts routinely place defendants on payment plans where you pay a certain amount each month. Courts also tend to have sort of default payment plans, and for courts of common pleas, that could be $50 or $100 a month, which obviously poses a problem for legal aid clients. One thing that you should know is that if you or the client can't enter into an appropriate agreement with the court collection staff, then you can always file a motion and request a hearing before a judge and ask the judge to set your client on a payment plan, because the payment plan needs to be something that the defendant can actually afford based on their financial circumstances. Clearly, if the client can only afford to pay $20 a month, it doesn't make any sense to have him agree to go on a $100 a month payment plan when he's just going to be unable to meet that, and is going to default, and then is going to face some additional consequences as a result. So I think that the main takeaway is payment plans. You always can go before the judge if you want to, even if the court staff doesn't tell you, or even if they suggest that no, you can't go before the judge. In fact, you can. And one of the motions that's on our website is a template motion that you can file if you're in that circumstance.
So payment plans are going to be particularly important for people who are trying to get public benefits that are have the lack of a payment plan as a barrier. In Philadelphia, we've convinced the court that you can be compliant with a payment plan if you have zero income by paying nothing, by getting your payment deferred. But they do tend to require the client to come back periodically to verify that he or she still has little to no income. But be aware that there sometimes is a way to be compliant for purposes of public benefits that does not involve the payment of any money.
Yeah, and I think that's a good point. I have a client who is waiting, doesn't need public benefits in the form of TANF for general assistance, but is waiting for SSI to come through. And I've worked out a deal with the court where he doesn't have to pay anything until SSI comes through. The downside is the court wants me to file monthly status reports saying, yes, he's still waiting on SSI. So if you can negotiate something that's more like maybe 6 months or a year or something that's a little bit more reasonable if you're in a circumstance where you're waiting for an improvement for your client's financial situation. Sharon, there's a question about what if a judge refuses to hear a petition for expungement until all costs are paid in full? What is the remedy?
Darned if I know. In fact, we've had cases, we've gotten expungement orders in. The judge says, yes, this case will be expunged even though there's still debt on this case. And the clerk's office tells us we can take it out of the public website, but we can't expunge it because CPCMS, the case management system, does not allow us to. So this is an issue that we've had a lot of difficulty with.
Yeah, I mean, there are some wackadoodle legal theories that I've thought about, but nothing that's really ready for prime time, shall we say. So for the time being, I think you're just sort of stuck with it. All right. Supervision fees. Supervision
fees. Okay. So waiving supervision fees is the thing that we want to most emphasize here in terms of curtailing people's debt. In part because, as we said before, it's often the biggest source of debt on the person's docket. The $25 a month adds up quickly. And also because there's explicit legal authority by the court to waive it. You'll hear how waiving other debts is a higher degree of difficulty in a minute. But it can be done. It helps clients a lot. Last week I was in court and got $900 off of somebody's docket. If you have a long probation sentence, it really adds up. You do want to check the court case and make sure the judge didn't already waive it in sentencing. That happens often in Philadelphia, that the courts put into the case management system, just based on the length of a probation period, that a person owed many, many hundreds of dollars in supervision fees. But if you actually look at the sentencing documents, you'll see scrawled there, supervision fees waived. So be careful before you even decide that there is a dispute. I would tend to double check to make sure that, in fact, it hasn't already been taken care of. If it has already been waived, I would just contact the clerk's office and say, look, here's the evidence, it's been waived, please correct this. So no filing should be necessary in those cases. Next slide, please. So here are the criteria out of the court or out of the statute for when people can get their supervision fees waived. And as you can see, it's a fairly long list that applies to most of our clients. Number 6 there is the old other extenuating circumstances, into which we throw any category that a client really needs supervision fees waived and it's not encompassed by the rest of them. So not difficult. In Philadelphia, there is a one-page form that for waiving supervision fees that basically has these criteria. You just check some boxes, and it's not real difficult. Andrew, I believe, has recreated that form without the First Judicial District's header on it, so you all can can use it as something to easily file with your court. Do go in and be prepared with your client to explain more than just that they support dependents, or that they are disabled, or whatnot, whichever criteria you might pick. But if you do it a number of times, you may find that it becomes fairly routine. In Philadelphia, we tend not to have to say more than about a minute's worth of argument before the judge usually rubber stamps it and says, fine.
And that more generally applicable statewide template motion is one of the documents that Kelly has shared with you. It also gave me the opportunity to correct some of the typos that were in the First Judicial District's template form. And we also, on our website, have a memorandum of law that you could potentially file and support, particularly if this is something that does not happen normally in your court and you want to make the judge feel at ease that, yes, you judge do have the authority to do this. So supervision fees are a big chunk, but there's, as you saw from that docket sheet earlier, there are still lots of other court costs that a defendant can owe. And this is going out a little bit more into the realm of more cutting edge stuff. I've often been told by judges that court costs are mandatory, they're set by a state statute, and no matter how indigent the defendant is or how much I want to waive the court costs for that defendant, there's nothing that I can do about them. And it turns out that that's not true. In 2010, there was a statutory amendment that basically made all people convicted of crimes liable for court costs unless the court determines otherwise, and it cross-references a court rule that gives the court the discretion to reduce those costs. We've had some luck with this. I've worked with several public defenders who have done this down the road. Because court costs aren't part of the sentence, there's good case law that says that they're not subject to the same jurisdictional hurdles that you would have for otherwise challenging the sentence. In other words, you can, even if more than 30 days have passed in sentencing, you can still get the cost waived. So years later, client comes to you, has all these costs, you can still go this route. There's a template motion, which Kelly shared with you, which walks through the legal authority for why the court still has jurisdiction, as well as what the statutes are. And I mean, the legislative history that goes along with this 2010 amendment really cannot be clearer. It says that it's intended to ensure that the courts have discretion to waive or even reduce or even waive costs in appropriate cases. So I would encourage you all to go that route as well. And you could do this in addition to or in place of a supervision fee waiver, because supervision fees are a type of cost. And so by doing this, you should that should also encompass the supervision fees. It's a strategic question for you in terms of whether you think better to do a piecemeal supervision fees first rather than if you're concerned that the more if you're concerned that the bigger ask might be too much for the court to swallow at once. So just something to think about. And if anyone's doing this, I'd be happy to provide some technical assistance with that. Another potential option in removing court debt is community service. Not all clients are going to be able to do community service because of potential disabilities, lack of access to transportation, childcare needs, et cetera. But there is a statute that provides discretion to the court to order community service in lieu of making payments. Because it's discretionary, you can ask the court for it, but they don't have to do anything. So the vagueness of the statute is good in the sense that there's no specific dollars per hour formula. So there's no reason, and indeed, I would advocate that judges should not be just tying this to minimum wage, particularly given how unrealistic the minimum wage is. You could also suggest some other ideas other than traditional community service options, such as job skills training or GED classes or some sort of drug or alcohol treatment if it's appropriate. Whatever you decide to do, if you're going to ask a court to do this, I would suggest coming with as specific ideas as possible, and name a specific place, how many hours you're going to have the person do there, et cetera, so that the court has a proposal in front of it that it can rule on accordingly. And whether you are trying to get your court costs waived or trying to get onto community service, the core question is what is the person able to afford to pay? And obviously you want to try to make as sympathetic a case as possible that there's really no realistic possibility your client's ever going to be able to pay this money off. So you should focus on things like whether your clients receive any sort of public assistance, including food stamps, Medicaid, et cetera. Obviously note that you're giving them free legal services. It's also helpful to show that they have, when in their underlying criminal case, they had a public defender. So it's not like at one point that their financial situation has changed so dramatically. Some of the touchstones that our appellate courts have used are whether someone's living hand to mouth or someone can't afford to pay without hardship. Essentially, I would advocate that anyone whose income is under 125% of the federal poverty level is pretty much by definition, at least presumed unable to pay. And you can use an income and expense sheet, sort of like an informal pauperous petition, to go through day-to-day expenses, rent, utilities, health insurance, transportation, childcare, et cetera. That formulaic approach can be helpful in some cases, and others it might not be. But we do have a form like that up on our website as well, in case you find that helpful or find yourself in this position. But those are the sorts of arguments that I would encourage you to make about your defendant's finances when asking to have costs waived, or when asking to have the defendant do community service instead of making payments.
Andrew, excuse me, if I could just launch the second CLE poll.
Great.
If you would like to earn a substantive CLE credit for this webinar, please respond to the poll now. Thank you.
And one person has responded saying that they are not actively participating.
We always have that one.
It might have been me, who knows? Okay, so we're running out of time, and that's too bad because I would love to tell you a lot about debt collection because it's very frustrating as part of this whole mess. I will tell you that we've seen levels of debt collection in Philadelphia that range from the fairly benign, the current debt collector for the Philadelphia courts, you do not hear from hardly at all until you approach them to try to settle a case so your client can get their case expunged. On the other hand, when the first judicial district was really going at it in terms of trying to collect, people were getting calls that a person after another were being told, if you don't pay this money, I can push a button and send you back to jail. And it's moments like that that you really wish that the Fair Debt Collection Practices Act applied. So we've seen some very awful situations. There was a client of mine once who was in the hospital and got a call from the debt collector there. I don't recall specifically how they traced him there, but yes, called for debt collection in the hospital. They can be pretty aggressive, and again, they are leveraging the fact that it's a criminal case to put even more force on the clients than they could otherwise. One of our fun stories during that time that the collections were quite strong was that the city had lined up a lawyer to do debt collection enforcement who herself owed a lot of real estate tax on her house, her expensive house that was delinquent. So needless to say, that went away quickly once that came out in the newspaper. But in any event, whether a debt collector is aggressive or not, there are at least two really problematic things that occur once a court has sent a case to private debt collection. And by the way, they are permitted by statute to do that explicitly. So although Andrew will tell you correctly that a legal finding of ability to pay is required, and may not have actually been made before the referral is made, the courts are sending, in many cases, cases to private debt collection. So two problems. Number one is, when it goes to collection, now there's an additional 25% collection fee that's added on the top of it. And for our clients who are trying as hard as they can to try to zero out their debts, to add another 25% can be the thing that breaks the back of the collection attempt, or our client's attempt to pay off the collection. It's just a bridge too far, especially if they have, say, high restitution, and that 25% can get into the thousands of dollars. The second bad thing that happens is that these debt collection agencies are often very difficult to deal with, not responsive, not even very eager to necessarily cash your client's check and tell the court that it's been paid. So I had a case earlier this year where we sent in the client's money on July 31st, waiting, trying to figure out what are they doing with the money. Would you please tell the court that it's been zeroed out? They finally reflected on the docket the payment in mid-September. So 2 months of waiting in order for that to be taken care of. Whereas if the collection authority hadn't been removed from the courts, the client could have walked in, given them a money order, and it would have been resolved on the spot. So collections are bad. How's that for a wrap up of that slide?
Just to interject, Kelly, a couple of people have posted in the comments that they didn't receive the poll.
Yes, I've responded to them privately.
Okay, great. And then there's also a question about if costs are not punitive, could they possibly be discharged in bankruptcy? My understanding is that the answer is no, that none of this stuff is dischargeable in bankruptcy.
I think actually it's a more complex answer than that, depending on the type of debt. One that I'm not prepared to answer today as a non-bankruptcy lawyer, and one that we should probably talk about if people have specific cases they want to discuss, because the answer to that is not a simple yes or no.
Yeah, there's a case actually pending before the Pennsylvania Supreme Court that raises this question with respect to restitution. And a gentleman named Henry Sommer, who I think used to work at CLS, is sort of the go-to person on this. And so if anyone has any questions about that and you don't have his contact info, feel free to reach out to me and I'll put you in touch.
Last slide as we run out of time.
Yes, so very quickly, your client is potentially, people who don't make payments risk potentially having bench warrants issued for them and potentially being scheduled for contempt hearings. If any of your clients are ever scheduled for a contempt hearing, I think the first answer is to refer them over to the public defender's office, because there they risk actual incarceration, and that's probably something that you want to leave to the public defender instead. So I'll just leave it at that, unless you want to say anything more, Sharon.
No, I would say do be aware, especially if you're in a county where you don't know how the county is going to react to the person showing up to pay their debt. Make sure they're not going to be taken into custody. I wouldn't be lackadaisical about that, but by the same token, nor would I find myself necessarily in a position where I was afraid to do this work because of the fear of that. Because I think in most circumstances, the courts are just delighted to get some money. So if people are showing up to pay in particular, I think usually they will be okay, but I really would, if you are not sure, check to see whether there's a warrant.
Okay.
And I believe that does it. And because we are out of time, I think we need to wrap up. But I encourage any and all of you to reach out to Andrew or me if we can be helpful on other issues here. I do hope, especially for those of you who handle criminal record sealing and expungement cases, to take a look at doing this, because once we move into the area of beyond arrest to convictions and getting them sealed or expunged for clients, as you know, it's really beneficial to our clients to have that happen, but it won't unless we zero out their court debt. And it's something we can do. It's an aggravating add-on to our expungement and sealing work, but unfortunately right now a necessary one.
Yes, well, thank you everyone for attending, and we have a bunch of resources on the ACLU's website with the link there, so feel free to check that out, and I'm certainly happy to discuss strategy with you all moving forward. Thank you.
Thank you.
Thank you. Have a great weekend, everyone.